Good morning, sir. You Desarian Adams. This is 23 DCCR 0492 and 0493 on both cases, correct? What's the announcement?
They've made an offer, but we're going to need a hearing.
Okay, so did we already go through the motion? Did we start going through it and then stop? Because I didn't make any notations of pleads of true or not true. I don't think.
Any on this one either.
What we did was I was read through all the violations except the new allegations. And you said, no, got to do them all. So we stopped. There's 2 misdemeanors there. I think one's a machine.
Okay. I mean, and I wouldn't have said, I guess as far as an agreement goes.
We will do the one. But it did not.
He did plead true to counts 3, 4, 5, 6, and 8. Reset for an update. So,
Something happened and we stopped because I didn't make the notations and we didn't get it updated. So let's start back from scratch. We'll go through the motion, get pleads of true or not true, and then we'll reset it for a hearing. No, ma'am. I'll take care of it. There's 2. The second one, please. Okay, so Mr. Adams, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You can put your hand down. And will your client waive the formal reading of the motion in each case? So, Mr. Adams, in cause number 23, DCCR 0492, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation September 26, 2023 for the 3rd degree felony offense of deadly conduct discharging a firearm. And that was a 5-year deferred probation. Is that correct? And then in cause number 23, DCCR 0493, I also have a motion to revoke your unadjudicated probation. This also shows you were placed on probation September 26th of 2023 for deadly conduct, and that was also a 5-year deferred probation. Is that correct? Both of these cases allege that you violated your probation. Count 1 in each case alleges that you committed the offense of fleeing a police officer December 6th of 2025. Is that true or not true? Count 2 in each case alleges that you committed the offense of unlawful carrying a weapon December 6th of 2025. And is that true or not true?
Not true.
Count 3 in each case alleges that you failed to avoid persons or places of disreputable or harmful character, and that on December 6th of 2025, the arresting officer stated that the vehicle operated by you and occupied by 2 passengers emitted the distinctive smell of burnt marijuana. Is that
right away? This probation hearing starts getting complicated. Notice how Adams pleads true to some violations, but pushes back on others involving weapons and marijuana. In probation court, that matters a lot less than people think. The prosecution doesn't always need to prove every allegation. Sometimes just a few admitted violations are enough for the judge to revoke probation entirely. And when firearms are already part of your original case, judges tend to pay very close attention to any new weapon-related accusations. Question for you guys. If someone admits to smaller violations but denies the major ones,
true or not true? Count 4 alleges that you failed to immediately report your arrest to the probation department. Is that true or not true?
That's true.
Count 5 alleges that you failed to provide verification of performing the community service hours as ordered in each case. Is that true or not true?
Not true.
Okay. Count 6 alleges that you were at a location other than your residence at approximately 11:23 p.m. December 6th of 2025. And is that true or not true? Count 7 in each case alleges that you were in possession of a firearm by having 3 pistols located on the back driver's side seat concealed under a black jacket in the vehicle that you were driving. Is that true or not true? And count 8 alleges that you're behind in your court-assessed fees as of December 8th of 2025. in cause number 0493 in the amount of $540, and in cause number 0492 in the amount of $2,942. Is that true or not true? Okay. Did you enter your pleas of true in each case to counts 4, 6, and 8 freely and voluntarily? I'm sorry. And did you plead true to those counts because they're actually true? All right, then I'm going to find those counts true, find that you entered your pleas freely and voluntarily, find sufficient evidence in each case to revoke your probations and find you guilty, but I am going to reset this case for a hearing. Do you anticipate, I guess, a little bit of time on this one with witnesses?
I think so, Judge.
Like,
There's up the offenses.
I'm sorry.
An hour.
Okay. All right. So we'll get it set for a hearing. I'll get an updated pre-sentence report. And okay, we'll do it on a different day than a docket day then. All right, you can go back with the bailiff.
You were right. Yes, sir.
Big excuses, man.
Yes, thank you.
Mr. Adam.
Good morning, you're Larry Fitzgerald Williams, and this is cause number 25 DCCR 0985 and 20.
And there it is, the moment the judge officially finds enough evidence to revoke probation. That phrase may sound routine in court, but legally it's huge. Once the defendant admitted certain violations voluntarily, the judge gained the authority to move this case towards sentencing and possible incarceration. But notice Judge West doesn't immediately sentence him. Instead, she schedules a separate hearing. That usually signals the court wants more testimony, more witnesses, or more context before deciding just how severe the punishment should be. This is one of those courtroom moments where the calm tone hides how serious the situation actually is.
For DCCR 1790, Mr. Williams is charged with capital murder as well as aggravated assault causing serious bodily injury. And what is the announcement, Mr. Cashin?
We need to take care of some housekeeping matters because the last time we were here, you had ordered the state to provide us with written notice whether they're going to seek the death penalty. And yesterday afternoon when I left my office, I had gotten nothing from the state as to whether or not they're going to seek the death penalty. And I would like that information as soon as possible in accordance with the rule that you have.
Smith?
State's not seeking that, Judge.
Okay, if you'll get that in writing to Mr. Cashin so he has it for his file. That way that gives him the opportunity to know how to move forward. I'd like to get this case, if it's going to be a trial, tried before the end of the year.
Yes.
And so I want to...
And there are some other issues, Your Honor. Back when we first came to court, I had filed a motion to quash the indictment because the indictment, from what I understood, was incorrect because it was under a wrong provision and it was for retaliation against the judge. And they have not corrected that in that indictment.
Just a minute, let me pull that.
Yes, ma'am.
So I think we discussed this, and it's only the heading,
Yes.
which is not substantive. Obviously, the substantive part of the indictment is what the actual charge is, which is the retaliation
Yes.
against Mr. Lewis. It's the indictment itself is not going to be quashed because of what's ultimately a typographical error in the top. I do think it's clean, or for the record, if you want to make an oral amendment, I think that's something we can do today.
Right from the state.
I think it needs to be correct as well. And it's not 18. I can't remember which one it is. Look, I know we had this conversation.
Yes, we have.
Do you remember which one it is?
In the very beginning? Well, I left that file in my office.
That's all right. I can figure it out.
Wow. That single sentence from the prosecutor just changed the entire trajectory of this capital murder case. The state's not seeking death. That is massive in Texas. Once prosecutors removed the death penalty from the table, the defense strategy changes dramatically. Jury selection changes. Negotiation leverage changes. Even the emotional pressure surrounding the case shifts. The defendant is still facing an incredibly serious charge, but now the maximum punishment likely becomes life imprisonment rather than execution. And look closely. Defense counsel immediately wants that decision.
Let's see, 19. Ouch. $1903 A.
Team. I mean, that is correct.
That is correct.
1903.
1903 18 is correct.
It is.
I can live
There
with
was something that I do recall us having a conversation about, but
Well, it says murder for retaliation, judge justice. I mean, that's
the
we
judge
can line
justice
through
needs
that.
to be interlineated, but the
Right,
section
that's-
number is actually
okay,
correct.
that's
Yes.
what I'm,
That's okay.
that need to be deleted.
Any object? Make an oral motion to
We would
do
make
that.
an oral motion to strike that from
Okay, and
Hold on. Any objection to that?
no, Your Honor.
All right, give me just a second to get it done before I move on. It doesn't want to give me that option. That's weird. And we need to, would you, make a note for a ticket? For some reason, the one thing that I need, which is the interlineation thing, is not letting me do it. And it hasn't. I'm just gonna print it. Yes, and we'll do it that way. Okay, what else?
We recently got an email from Mr. Smith about some discovery, and I bought a 1 kilobyte, or 1 terabyte drive to be copied, the information that he's referring to.
Okay,
And so I would like that. Then I have a motion to change venue right here, but I need to get Mr. Williams to sign his affidavit, and it will be filed this morning.
okay. So with regard to discovery, y'all can take care of that.
Yeah.
I don't need to get involved in that. And then once if something is filed with regard to a change of venue, I'll get that set for a
Yes.
hearing within the next few weeks.
Yes.
Obviously,
This exchange is classic courtroom procedure mixed with little legal nitpicking. The defense is arguing there's a problem with the indictment wording, while the judge basically says, yes, the heading may be messy, but the substance of the charge is still legally valid. A lot of viewers hear terms like wrong statute or incorrect indictment and think the whole case gets thrown out Hollywood style. In reality, most clerical or formatting errors can simply be corrected with amendments unless they seriously harm the defendant's rights. And honestly, you can tell everyone in this courtroom is trying to clean up the paperwork before this case heads toward trial.
that's something we'll need to get taken care of so everybody can plan ahead on what we're doing. So once it's filed, I'll
It'll be
give everybody an opportunity to get ready and we'll get something set.
that'll
I
be
would
done.
say within 2 or 3 weeks.
Thank you, ma'am.
Okay. Anything else?
That's it for now.
Okay. All right. If you can, if you need him to sign that in front of,
Notary.
if you can step over here in front of the clerk, she'll take care of that.
Thank you. Thank you, Judge.
Thank y'all. She's gonna go get her
Notary.
notary.
See you.
Good morning. You're Bobby Clark, and this is cause number 25 DCCR 0802. Mr. Clark is charged with indecency with a child by sexual contact. And what is the announcement?
Judge, this was set to this court date for a status Ms. French had ordered the CPS records.
Hold on a second. I need y'all to all hold it down, please. Go ahead.
Ms. French has, through the court obtained CPS records. We both have copies of those.
Okay, good.
So I think at this point, we're needing to just set this back on the trial docket.
Okay.
There's already a rejection on mine.
Has there been any change in what the offer was? It looks like it was back in August of last year. There was a rejection of a 12-year term.
Correct, Judge. And I don't know what Ms. French intends to do, but I do know that she is planning to meet with the complainant soon.
Okay.
And we talked about that today. If there is a change, we would obviously bring that to the court's attention
Sure.
beforehand.
Let's go ahead and get it on a trial
yeah,
date.
just because of the nature of the case, I think.
Yeah, for sure. All right, so Mr. Clark, I'll get your case set on the trial docket. If something changes with any negotiation, y'all just let me know as soon as that changes, and we'll get you back in here. Otherwise, we'll see you at the next on the first trial date. Okay. Trying to go back to the bailiff. Thank you.
Wait, Jim.
What's happening? Hey, Mr. Gertz.
This hearing just took a dark turn fast. What started as an aggravated assault case is now becoming a murder prosecution because the victim died 78 days later. That's one of the most dramatic charge escalations you can see in criminal court. And notice the defense immediately asked for more time. That's completely expected. A murder case brings entirely new evidence into play. Autopsy reports, medical findings, causation arguments, expert testimony. The stakes increase overnight. Backhand index point right, let me ask you this. Should prosecutors upgrade charges automatically?
Mr. Kimler. Oh, he's in trial. I wonder if. Well, did he say anything about? Against Ryan's on our docket. Would you shoot him a message to come take care of Spites real quick before he gets going in trial? Thank you very much. Appreciate you. Logan Eaglin, Ms. Perazzo. Good morning.
I didn't know.
Good morning. Are you Logan Eaglin?
Yes, ma'am.
And I'd really need y'all to, if y'all are talking about a case, don't walk across each other, get closer. I'm having a hard time this morning for some reason. Mr. Eaglin, this is 25 DCCR 0897. You're charged with aggravated assault with a deadly weapon. Your case is set for trial to begin with jury selection next Monday. And what is the announcement?
Judge, this is a case that the state will dismiss because we're re-indicting as a murder. We found out the victim died approximately 70 days after the assault.
Okay.
Would be not tried as the aggravated assault, but tried as a murder.
When do you anticipate that indictment?
I think it will go tomorrow.
Okay. So obviously if that's going to happen, it doesn't change a lot of the discovery, I wouldn't think. And so
Judge West handles this transition pretty methodically. She acknowledges the prosecution's upgrade to murder, but she also makes sure the defense has time to review all the new discovery before trial. That balance is important because criminal courts aren't just about punishment. They're also about making sure both sides have a fair opportunity to prepare. And you can feel the atmosphere shift in the courtroom here. Earlier, this sounded like a routine aggravated assault docket. Now it's turning into a full homicide prosecution with higher stakes, more evidence, and much heavier consequences hanging over everyone involved.
we can go ahead and leave it on the trial docket.
Yes,
Because you've already got everything. It just changes the nature of the offense, correct? All right. So, but I guess, I mean, if it's indicted tomorrow, it changes it enough to where if you need some time, you're entitled to that.
yes, Your Honor. If we could have just at least 30 days.
Yeah.
There will be at least an autopsy report,
So
pictures.
potentially
things,
some additional things for you to go over.
actions.
Okay, so what I'm going to do, Mr. Eaglin, is reset your case to the next trial docket, so that once Ms. Barrazo gets everything, any additional discovery, which it sounds like there's some more information coming because the case is going to be upgraded to a murder charge instead of the ag assault. We'll give her some time to go over all that, go over all with you. If there's any new offers or plea negotiations, then let me know. If something changes before that trial date, we can get it taken care of.
Yes.
Okay, you can go back with the bailiff. Let's see, Mr. Smith, Mr. Wilkerson, let us know that he is not going to be able to be here today, but that you already let him know. Are you ready on Dalvius Williams? Oh, okay. We'll finish with Dalvius
Yes, ma'am.
Williams. Thank you, sir. Mr. Radford, you have Floyd Torin, sentencing. Good morning.
Why did you get the medical records and things?
When did you? Who'd you send a medal to?
Kelly,
When?
No, I emailed him about it 3 or 4 weeks ago.
Did you email him to Mr. Smith as well?
Did you get the medical records thing?
Did you sound better?
About 3 or 4 weeks ago.
Yes, I think I did. You emailed him.